All right, so I'm not going to really spend any time on the Second Amendment, Third Amendment. We've talked about the Second Amendment corporation case with D.C. versus Heller and Chicago case. Okay, so getting into rights of the accused and what are, I'm sorry, the Third Amendment. We're not allowed to quarter troops. Government can't make us pay for soldiers anymore. Has not yet been incorporated. The government hasn't tried to do that yet since after the Revolutionary War. So I will say, though, that some people will want to use the Third Amendment in conjunction with some other amendments in the Bill of Rights to talk about the whole right to privacy, okay, in kind of a broader sense. All right, so as we look at the rights of the accused and some exceptions to these, and there are a couple, certainly some landmark cases that we need to be aware of. All right, so the Fourth Amendment, all right, protection against illegal searches and seizures, right? In order for the government to, or for law enforcement to search your home, it has to have a what? It has to have a warrant. And in order to get a warrant, they have to be able to show nope. Probable cause. Okay? Probable cause. The reasonable suspicion standard is for schools. We'll talk about it here in a second. Okay? So this is important. Historically, if you look at the time before the the Revolution, is that the British government were issuing writs, okay, where they basically could just go into homes and look for whatever they wanted to. Okay, so the idea of going back, clear back to Locke, right, with life, liberty, and property. This is very much an example of the writers of the Constitution and Bill of Rights wanting to protect people's properties. Okay, so here's a question. What are some exceptions to the search and seizure or warrant requirements when it comes to it? Do you know any exceptions? Who's on mock trial? Anybody on mock trial? No? Then I know that.
I'm a timekeeper.
Okay, because this is your case, right? This is the topic. It's based on that this year, I believe so, right?
Yeah.
Fourth Amendment. Go ahead. You know exception?
Clear and present danger.
If okay, so we've all watched enough cop shows, right? So like, if the cops are like walking by some apartment building or business and they hear somebody scream or a gunshot go off, they don't need to have a warrant to bust in, right? They believe, there's somebody in danger, there's a crime being committed. Okay. What else? You don't have to have a warrant. Huh?
Reasonable suspicion.
No. Yes.
And then I just said, we're in places where citizens cannot reasonably expect privacy.
Okay. Or can citizens not reasonably expect privacy?
Airports.
Okay. Airports. Right.
They can do that schools, right?
Okay. Well, you guys keep bringing this reasonable suspicion thing up, so let's jump ahead to the school. So this would be a case you need to know, TLO versus New Jersey, which dealt with students that they were suspected of having drugs on them, and the principal made them dump their purse on the floor, and they found evidence of this, and the students sued, saying that it had violated their Fourth Amendment rights because they didn't have a warrant to do that, and the students lost. Okay, because the courts, and we talked about this with the First Amendment, right? The courts have ruled that there is a difference with schools, and the standard in schools is reasonable suspicion. Okay, which really doesn't mean anything to us. They're just words. Like, what's the difference between reasonable suspicion and probable cause? Okay. The only difference is to know that reasonable suspicion is a lower legal standard. Okay? That's a lower legal standard. And reasonable suspicion, doesn't have to involve law enforcement necessarily. If You know, if our administration saw something on camera, or they have a couple students that have come to them and said, hey, you know, we're concerned, we've heard the student has a weapon, you know, that's reasonable suspicion, that's enough. They're gonna be able to search, right? Ask for a search. You can ask for, you know, the resource officer to be there, you know, they'll call your parents, but them searching they don't actually have to have a warrant, okay? And so TLO is an example of that, and that the standard is much lower in schools. They don't have to have a warrant. I'll give you my Fourth Amendment school story, okay? So this would have been, a while ago, when Mr. Crispin was the assistant principal. Okay, you guys don't remember Mr. Crispin, you might know the name, but he was the assistant principal. And it's the last period of the day, when Mr. Crispin was a big guy. He comes to my door, has me step outside. Matt, Steve, he says, I don't know how to say this. It's really awkward, so I'm just gonna kind of come out and just say it. I'm gonna go, okay. He goes, the drug dogs were going up and down the cars in the parking lot, and this dog hit on your car 4 times, indicating that there's something in your car. He said, so there's a plainclothes police officer downstairs waiting, and you can either voluntarily let them search your car, or they'll go get a warrant and come back if, you know, if that's what you want, what you want to do. So I said, oh, whatever, I'll go down there and search my car, and I'll cover your class. So at the exact same time, Mr. Crispin's in here like teaching my class something on Native Americans, I don't know. And right outside this window, unbeknownst to all my students, the police are searching my car for drugs. So we're heading down the stairs, and all of a sudden it hits me. I start to get worried. Well, I get worried because the car that I was driving at the time was, my parents had given me this car. It was an older car. It did not have automatic locks. Okay? Which I know that's hard for some of you to envision, a car without automatic locks. So I would get lazy, and my boys would ride in the back seats, and I didn't always worry about making sure that all the cars, I don't have anything to steal, apparently, right, in my car. So I'm like, back doors were open, and some punk kid threw his bag of weed in my car to ditch it. And so I'm gonna go down there, and they're gonna find this, and it's not, so then I panic, right? So then I get on the phone, and I call my best friend, who's also a lawyer. And I go, John, he goes, Steve, that's my name. I said, this is what's happening. He goes, just wait, relax, it'll be fine, I'll walk you through, let me know what the officer's doing, yada, yada, yada. So, the guy did his job, I think a little bit too thoroughly, and it was just kind of silly. So, so he opens up my passenger side door, and there on the floor of my passenger side door was a large bag of scrumptious dog treats. Because at the time, I had been taking my then puppy golden retriever to obedience class, and you have to take little treats for them, right? And so this dog hit on this bag of scrumptious dog treats. End of search, right? Done? No! Because apparently that's a good distractor. You put dog treats in your car if you're trying to hide your drugs, because then you can save. So he goes on, he continues the search. This is when it gets kind of humorous. I'm not making this up. So I had a trash can, one of those car trash cans in the middle. And I don't know if any of you have noticed, but I tend to drink a little bit of coffee. Okay? And I had sugar packets. And there's like white, and he literally does this. He goes, what's that? And he starts to get on his phone like he's going to call it in. And I'm like, sugar? That's why there's been packets of McDonald's sugar there. He goes, oh, okay. End of search, right? No. Can you please pop your trunk? Okay, trunk. Lifts up the fake floor, you know, and the trunk goes through this bare tire well and everything. Nothing there. Done, right? Nope. Can you pop your hood?
What?
Sure. Looking behind the the lights and all these different premises in the, I found out all kinds of places apparently where you're supposed to store your drugs if you're hiding it from the
See, now you're an expert.
Apparently, yeah.
You don't hide there, but
Now
Um,
you can actually hide your weed.
Yeah, so, that was my, interaction with the Fourth Amendment, but I'm giving you an exception to the rule in that. You can give consent for a search, they don't need a warrant, right? Now, here's the issue, and we, again, we've all watched enough cop shows to know this, is that sometimes you have a right to refuse a search, okay? And I'm not encouraging you not to cooperate with law enforcement, please, on YouTube, I'm not encouraging my students to not cooperate with law enforcement. But they certainly make it seem like you don't have a choice, right? There is that intimidation, police are allowed to lie to you, that's been held up in courts lots of times, right? So, a lot of times people will consent to a search. And they didn't have to do it, okay, so there's another exception. Evidence in plain sight, you guys have heard that, right? So like, if you're gonna commit a crime, right, you're gonna decide to murder somebody, and you let the police into your house, don't leave the gun on the coffee table. They don't need a warrant. So, you know, why is this gun here? No reason, it's a conversation piece. See, it started a conversation. So evidence in plain sight doesn't need a warrant. Trash cans, if it's on public property, there's no expectation of privacy. However, this is becoming more and more of a complicated issue. I don't want to get into it. We can spend an entire week talking about all the ins and outs of it. But when we start talking about telecommunications and social media and even things like, you guys have seen all those DNA test things, right? Those companies aren't owned by the government or run by the government. And if you give your DNA to them, they basically can do whatever they want with that DNA. If the government wants it and they're willing, they can give it to the government. You have no legal right or constitutional right to your DNA, right? There's all kinds of new exceptions, okay? What else? Yes?
So like with Apple and the older iPhones where it was the thumbprint,
Right.
and the government like get access to all of our thumbprints?
No, not,
Cause like Apple technically has them,
yeah.
but like,
And Apple's gone to court, I believe, a number of times, and it's always won. Where the government, the law enforcement has gone to companies asking for them to break into phones, and they won't do it. But it's not that they couldn't say they would, you know, they could, right? So the big case with, besides the TLO case that you guys need to know, and somebody's assigned it in this class, would be what? Who has the search and seizure case in this class?
Oh, yeah,
Okay,
that's
right, so Mapp versus Ohio, establishes what we call the exclusionary rule. Okay, and that's an important term, the exclusionary rule. That evidence that is found illegally can't be used in court, okay? So that incorporates the Fourth Amendment exclusionary rule. You know, Darlene Mapp, they went to Darlene Mapp's house, I think she lived in Cleveland, they were looking for, I believe, stuff related to a bombing suspect.
Yeah, they were looking for the suspect.
She requested a warrant, they came back with a warrant that wasn't actually signed or done, and like stuffs it down her shirt.
And then they took it back.
So, and then they find, at the time, a law in Ohio that what she had was considered to be pornographic material and against the law. So they arrested her under that provision because they found this material, and then she sued and said, look, you didn't have a right to search my property to begin with, and this had nothing to do with what you were looking for to begin with. So that evidence they found was excluded, and now we have the exclusionary rule, okay? You know, there are other exceptions. The courts are largely still favor law enforcement in the sense that if they make a good faith mistake, or let's say they transpose a date on a warrant, does that mean that the warrant's no good? You know, courts aren't gonna throw out evidence, that kind of stuff. But there's been talk about, you know, really kind of lessening the search requirement provisions, but you know, what would law enforcement be like if that were the case? So the other controversial thing related to this is stop and frisk. You guys ever heard of that law? Stop and frisk laws. This is big in New York City. Basically, they have kind of like what you guys said, reasonable suspicion that you're involved in a crime or a crime is being committed in that area, and they stop you. You know, and you have to stop legally if the police ask you to stop, right? Or, you know, identify yourself, so on and so forth. And then to frisk you. The reason this has been challenged is it's been largely kind of believed to be race-based. Like is it a coincidence that 98% of the people that you're stopping and frisking are African American or Hispanic? You know, probably not. Because the police, you know, if you ever are arrested, the police are going to frisk you. They're going to ask you things like, is there anything on your body that would harm me, and so on and so forth. And that, not have a warrant to do that. That's a safety issue for the police, and so on and so forth. So it's more and more of an issue. You know, what about drones? You know, space above us. Do they need a warrant for it? It gets very, very, very complicated. For our purposes, we're not going to delve that deeply into it. But just to know, this is an ongoing issue. Okay. Okay. The Fifth Amendment. Okay. This gets into largely things dealing more with trial, right? So as we're going through the Fourth, Fifth, Sixth Amendments, even the Seventh Amendment, we're talking about kind of due process. What, you know, the procedure, not substantive, but procedural due process. What does the government have to follow, okay, when it comes to criminal proceedings? So we have protections in the Fifth Amendment, right? We have the right to a grand jury. Anybody know what a grand jury is? Yes.
A group of people charged with particular evidence.
Do you know what that means?
It's pretty much like, this is like a judge deciding or something.
Yeah, I mean, you ever hear, again, let's go back to cop shows in some level. So this person's been indicted or charged with this crime. You know what that means? They put together this large group of people, and the prosecution, right, like the district attorney, is going to present evidence saying, this is the evidence that we have. Do you believe there is enough evidence to charge this person with this crime? It doesn't mean that they're found guilty of that crime. That just means that they have found enough evidence that there's going to be a trial to determine if they're guilty of this crime. Okay? So that's a grand jury. And it doesn't take a big burden of proof, right, to indict somebody for a crime. Okay? Or they may look at the evidence and, you know, the district attorney wanted first degree murder, and the grand jury comes back and says, no, we're only going to indict for second degree murder. Okay? Self-incrimination is a big one, right? And the Fifth Amendment, you don't have to testify against yourself. Okay? Either before like a congressional hearing, or in a trial, right? You have the right, this is where you usually hear this, right? You have the right to plead the fifth, right? What I don't have to say, oh yeah, I did it. Okay? You have the right to remain what? Silent. Okay. So that leads us into the Miranda case, right? Where Ernesto Miranda, this would be a landmark case that we need to know. Basically confesses to, I believe, murder and rape, and didn't know that he had the right to an attorney, didn't know that he had the right to remain silent, and so they basically throw out his confession. A lot of law enforcement was very upset by this ruling of the court because many believe, if you look very strictly constitutionally, that there's nothing in the Constitution that says you have a right to know your rights, and we have to tell you to take it. So the Supreme Court kind of found that, you know what though, if you look at this, how else are people going to know their rights? Because they all don't obviously have, you know, a great advanced placement in government class to know these things. We're going to make sure that you know that. You have the right to remain silent. You have a right to an attorney. Whatever you say can be used against you in court of law. Do you understand these rights as I've read them? And they make you sign it as evidence that you have agreed to this, right? So that's the Miranda ruling. Interesting story. that I have really kind of combines Miranda and the Fourth Amendment. So I've told you about my friend a number of times that's a judge in Athens County. And right when he basically first got on the job, they had this unusual case. So the police were going to this individual's house who was being arrested for child pornography. And so they have the arrest warrant. They have a search warrant for the property, I believe. And, you know, so they get the gentleman, they have not Mirandized him yet, and they're handcuffing him, they're, you know, doing all these things, and they ask a question, which they typically will ask, which is, do you have anything on your body, your possession, that you would not want to take with you to jail? And the guy says, yeah, I have my cell phone on me, I don't want to take my cell phone. So here's the bewildering thing, why the police officer asked this next question, what he did. And again, he's not been Mirandized yet. So the guy says, police officer says, why not? And the guy says, because I have child pornography on my phone. Here's the question. He had not been Mirandized. He was questioned by a police officer. It was clear that he was under arrest. Would they be able to use that information against him in a court of law? Since he had not been Mirandized, what do you think? Is that a violation of his Fifth Amendment? Is it an unreasonable search? Is it an illegal search? Probably not. Reason being is that in the course of the investigation, is it reasonable to believe that the police would have found that phone anyways? Right. So just because he confessed that he had this on his phone, you're right, we should have told you you had the right to remain silent, but we would have had your phone anyways, would have searched it. Well, okay. All right. The other protection in the Fifth Amendment is double jeopardy, which means what? What'd you say? You get twice the points. You get double the points, double the point value. Okay? You can't be tried twice for the same crime, correct? Okay. So that, you know, there are exceptions to this, okay? The most obvious exception is if you appeal your own case, that's not double jeopardy, right? If you're given another chance at a trial, if you were found guilty, that's not double jeopardy. That was one of the things that Gideon tried to argue when they made him get retried, this time with a lawyer. He's saying, well, that's double jeopardy. And the judge said, no, that's not double jeopardy. You're getting a chance to prove that you're innocent, right? This is to prevent the government from going after you time after time after time to try to prove that you're guilty of the same crime over and over and over again. I mean, the exact same crime. Okay? I don't mean you murdered this person, you're found guilty, you're not guilty, and then you murder somebody else. You can still get tried for that new one, right? So, exceptions to double jeopardy. What if you commit a crime that is a federal crime and a state crime? Can you be tried in a state court and a federal court? Yes. Yeah. Ask Michael Vick. Anybody know who Michael Vick is? Okay. He was a quarterback in the NFL that liked to engage in dogfighting. And there are federal laws against dogfighting, and there are state laws in Virginia where it was going on against dogfighting. He got tried in both courts. What else? Jeopardy exceptions. There's another one that I'm thinking that does not count as double jeopardy. Oh, this is a big one. If you're charged criminally, and then if there is another civil suit brought against you, okay? So we get into the difference between criminal law, which you're actually breaking a law, and the prosecution is going to be the government. And you get into civil law, where somebody is saying that there's some damage that's been done to them, so they're seeking usually monetary payment for this damage, right? Perfect example, how many of you know O.J. Simpson? Okay, so O.J. Simpson was found not guilty of murder in his criminal proceedings, okay? The family of one of the people killed charges him civilly with what is known as wrongful death, okay? So in this wrongful death civil case, and the burden of proof in a civil case is less than the burden of proof necessary to convict somebody of first degree murder. He is found guilty in the civil trial for wrongful death and is ordered to pay millions of dollars to the family of the one individual that was killed. Okay? That was not considered to be double jeopardy. That would be an exception. There's Ernesto Miranda. Right, Mac versus Ohio, exception to the exclusionary rule. Okay, Sixth Amendment. I don't think we need to spend a lot of time on that, right? Gideon versus Wainwright. Pretty much know it at this point, I hope, considering that you guys did your case portfolio. Okay. Sixth Amendment, though, has other exceptions in it. Okay? Dealing with the jury, right? We have the right to a jury, but we also have the right to a jury of what? Our peers. Which means typically that you're gonna, if you're accused of a crime in Union County, where's that jury have to be from? Union County, right? Other things that the courts have put in place is a racial balance, right? Some juries over time have been ruled unconstitutional because you have an African American male being accused of murdering a white woman, and the jury are all white men. That's probably not a jury of this person's peers, right? And that's been found. So that's not, that's unconstitutional when it comes to this. You have the right to a speedy trial, right? They can't keep you in jail forever and not give you a trial. Oh, well, we're still waiting, we're blah, blah, blah. They can't do that, okay? And you have a right to confront your witnesses. If somebody's saying, hey, you did this, or I saw you do this, you have the right to cross-examine them, you have the right to bring your own witnesses for your side of the story, and so forth. Now, there are exceptions to these things, okay? One, let's talk about the speedy trial part. It's not unconstitutional if you can't get something on the books because the court schedule is backed up. That happens. It's not unconstitutional if a lawyer asks for a continuance or for a delay if the judge grants it. Okay? It's not unconstitutional to ask for a change of venue. What's a change of venue? Location. Why would you maybe ask for a change of location for your trial? I think it would be hard to get an unbiased jury in Union County if you're accused of the murder and rape of a young child. It's going to be in the newspapers all the time. Everybody knows you. Everybody's heard all the stories. Do you think it would be difficult to get an unbiased jury, right? Because you're innocent until proven guilty, right? So if that happens, could an individual say, hey, I want to change the venue. I want this trial to take place in Cuyahoga County, where I probably have a better chance of getting a fair trial than in Union County. Yeah. Okay. So that wouldn't be considered to be a violation of the jury of your peers. Okay. What else? And that does run into the conflict of right to a free press and the right to a fair trial. Okay? Can a judge bar the media from a trial? We have the right to a public trial. Can a judge bar the media from a trial? No. Can he bar or she bar cameras? Yeah, right? We don't have cameras in the Supreme Court. Can a judge order a jury not to speak to the media or not to watch the news? Yes. Can a judge order a jury to be sequestered? What does it mean to be sequestered? What's the term? Sequestered. So you know? Sequestered. Yeah. They basically put you up in a hotel and don't let you speak to anybody, right? Because it's so high profile that, right, they need to keep you separated for the length of the trial. Okay. Yeah, so we definitely get into a conflict of the role of the media in reporting on these things and their First Amendment rights and our right to know as public with, does that interfere with an individual's right to a fair trial? Okay. To sequester, how do you spell sequester? S-E-Q-U, sequester? Okay.
ESTR probably.
Yes. Okay. All right, Eighth Amendment, cruel and unusual punishment. No excessive bail. Most commonly used to discuss what issue today? If something's cruel and unusual or not? Huh? The death penalty. Is the death penalty cruel and unusual punishment? And the best answer to that question right now would be no. The Supreme Court has ruled that in and of itself, the death penalty is not cruel and unusual punishment. However, there are a bunch of other cases that come into play if, you know, like in Furman versus Georgia, if you could show that this person basically was unfairly given the death penalty because of their race, that's obviously cruel and unusual punishment, and also a violation of what other amendment? Press me. Someone's been, huh?
14.
The 14th, good job. Okay. Obviously we don't, you know, one of the big controversies is what if you commit a crime, a capital offense, right, murder in the first degree, and you're 16? Can they wait and execute you when you're 18 if you're charged as an adult? We don't execute the mentally disabled, right? And so forth. We also don't execute anybody in this country anymore for anything other than basically first degree murder, with the exception being some military examples in time of war. Okay, so that video we watched, you know, I don't know if it was this class about, did we watch this video about the guy growing marijuana? I mean, no. Oh, there's these old laws on the book that say if you have this much marijuana, blah, blah, you can receive the death penalty, blah, blah, blah. No, not anymore. All court cases. All case law said that's not a thing anymore. However, here's the issue. Though the courts have ruled that death penalty is not cruel and unusual in and of itself, they obviously have looked at methodology, okay? They've looked at race, they looked at circumstances, obviously there's an appeals process, all this, okay? However, it's also still done by state. Not every state has the death penalty, okay? And this can become an interesting debate to a degree, is like, why do we have the death penalty, right? Do we have the death penalty because it actually prevents people from committing violent crimes? I'm going to say yes. If the state has a death penalty, it helps lessen the amount of violent crimes in that state. How can we show if it does or it doesn't? Objectively, how can we demonstrate that? Maybe. Every time we do it, does the crime rate go down? Well, can't we just look at a state that has a death penalty and a state that doesn't, and say, is there a statistical difference in violent crime between those two states? And if there isn't, could we say, well, death penalty is really not doing that, right? I mean, there's a lot of variables involved there. Because the thing is, we don't have public execution, right? You're executed before, you know, your family, the victim's family, but, you know, it's not like we hang people in the town square anymore to scare people. Right? The other thing is, it comes up is, well, the death penalty is so much cheaper than keeping someone in jail for life. Is that true? Seems like it would be. No, it's not even close. Keeping someone in jail is far cheaper than executing somebody under our system, because of the appeals process, being on death row. It's far cheaper keeping someone locked up for their life than it is to execute somebody. So then obviously, what's the best argument for the death penalty? Most people would probably say retribution, punishment. If you do a certain crime, you deserve to lose your life. Okay? Because those other two arguments don't really hold a lot of weight. But it's hard to argue, if you're this passionate about it, that if you commit a certain act, you should have your life taken from you. Okay? That gets more into morality issues. Yes?
This might sound kind of like, I don't know, brutal, but a lot of the time isn't it like, like a lot of the people who get getting the death penalty, it's like not really even punishing them because they wanna die in the first place. Yeah,
A lot
like,
of times everybody does.
yeah,
we just don't want them
like,
to go to jail for that.
the shooter in Pittsburgh, he openly said that he didn't care if he got the death penalty because he was planning on killing himself that day.
Yeah, I think that's a case-by-case basis, I don't know if that's the issue. I think what the bigger issue, what you're talking about is, and again, this is more of a, what's the purpose of punishment in our society? Is it more of a punishment to keep somebody in, prison for their lifetime than just to end their life? I think that's, even that in and of itself is an open-ended question, because it all depends on what's your perspective of life, what's your perspective of eternity, whatever. And it's a lot of other questions, right? So it's then where does government step in, and what's the role of the government when it comes to that? So, all right. Well, I'm going to stop with that. That's a lot for today. We really don't have this much more to go over in this chapter. Okay. So you guys should be into chapter 5. Okay. And looking at civil rights. We did that a lot with those flex groups, so hopefully you guys have some decent foundation when you're looking at some of these topics and the Equal Protection Clause, and then maybe begin to see, we saw a little bit today, how these rights of the accused especially can start to overlap with civil rights when we start to apply rights of the accused differently to different groups of people. Okay?
I have it right here. Cotton spinning machine. Eli Whitney was cotton eating. Ellis
Yeah.
Yeah.
After I finish this up, we're in chapter 5.
Yeah.
Yeah.
We made the cotton gin. Eli Whitney.